to the second up into the murder to the second as well. And then we believe that by not clearly defining the conduct, by leaving the definition of this conduct to, for example, prosecutors or judges to define, or more likely a jury to define, it creates a situation where the statute itself is unconstitutional for that vagueness. In federal vagueness cases, courts construe the statutory language in context, determining whether the statute itself or prior construction provides sufficient notice to the defendant. Reviewing Georgia law, this appears to be a case of the way this case is charged in regards to the cruelty of the second, meaning our client is charged by either doing or not doing certain actions that led a third party to do the action which makes up the basis of the cruelty in the second. By interjecting that third party, not only does that create issues with proximate cause, as my co-counsel will further elaborate on, but it also leaves not only the actions or the actions that define the crime vague, but it doesn't put an ordinary citizen on notice of what the prohibited conduct would be. And in terms of looking at case law for the Court of Appeals or for other courts or Your Honor to determine definitions of prior actions that have led to this charge, the way it's charged in this case by that extra third party causing the action that makes up the cruelty in the second, there's very little case law for the court to look at. And there's very little case law for my client to be informed on what the prohibited action is. Wholly separate from any federal claims, defendant also demurrers to vagueness on both separation of powers and privileges or immunities grounds. In Georgia, all crimes are defined by the legislature. The power to define crimes and prescribed punishment has long been held to be an exclusively legislative power. And in criminal law, the legislation can only exercise that power constitutionally if it defines the crime with clarity and precision. When the legislature adopts a statute that renders an essential element subject to the jury's unfettered discretion, such in this case with the definition of cruel and excessive physical or mental, then we lack the clarity necessary to put the defendant on notice as to what it is the prescribed conduct is. By leaving that definition to the jury, then in each case, the jury itself construes the law for itself. What that means is that there's no chance that a final construction of the law that would occur and the limits and duty imposed remain unsettled until after the fact. Here, by constituting or by making what constitutes cruel or excessive mental or physical pain depends solely on the jury's discretion, the cruelty to children in the second statute is abdicating the legislative power to the judicial branch. And instead of knowing with certainty and definiteness what conduct is prohibited, the defendant is left at the dark, subject ex post facto to the random determination of the jury. Judge, we feel the same argument applies also to reckless conduct, because it's also a statute that depends upon the determination of a jury after the fact as to what conduct constitutes a gross deviation. So it's the same argument in terms of abdicating the power of what the prescribed conduct is and taking that away from the legislator and bestowing it upon the judicial branch to determine. For those reasons, Judge, and I will just make for the record, we also believe that there's an issue with proximate cause and that my client's actions as this indictment has been charged were not only the proximate cause of the death charge, but also a reasonably foreseeable consequence. But as I said, I'll let Mr. Berry address that more fully in his presentation. Thank you, Your Honor.
Thank you. Ms. Brooks? I assume Ms. Brooks, but...
Your Honor, I have our cases on a jump drive for the defense for the court. And I do have a quick clarifying question. The actual general demurrer motion that was filed by defense does not allege anything about unconstitutionality, and it alleges just, the general demurrer that a crime was not alleged. So are they abandoning that allegation?
Judge, we won't abandon it, but we'll just leave it as it's been addressed in the motion for the court's determination.
Well, I'll address the general demurrer first, Your Honor, and then Ms. Daniels pulling up some cases on constitutionality.
You're going to do the general or the specific? You argued the specific.
I argued the general, and Mr.
I'm sorry, I thought I heard you say you.
Specific.
I was a little confused. Okay.
No problem, Judge.
Go ahead.
So essentially, Your Honor, pursuant to Kimbrough versus State, which is 300 Georgia 878, a Supreme Court of Georgia case from 2017, to prevail on a general demurrer, an accused must be able to admit each and every fact alleged in the indictment and still be innocent of any crime. An indictment is sufficient to withstand a general demurrer if the admission of the facts alleged would lead necessarily to the conclusion that the accused is guilty of a crime. So ultimately, if the defendant's actions can rise to the level of criminal negligence, then the indictment is good against a general demurrer. And I think Kane versus State is a very informative case on this, and that's 287 Georgia Appellate Courts 45, a 2007 case. The defendant there was charged with cruelty to children in the second degree based on allegations that with criminal negligence, she had caused the children cruel and excessive physical and mental pain and suffering, to wit, a drowning death, by failing to reasonably supervise and reasonably watch said children. So there, the defense counsel argued the allegations of the indictment were insufficient to charge the defendant with a crime because failure to supervise or reasonably watch one's children does not amount to criminal negligence. The Court of Appeals held that the indictment was sufficient and found that while the failure to reasonably supervise one's child may not in itself constitute negligence, such dereliction certainly may rise to the level depending on the circumstances. And that is what we have here. The indictment is not subject to general demurrer because the conduct can rise to the level of criminal negligence. And each of the counts are based on criminal negligence, so the argument for each count is generally the same, and that's pursuant to Johnson versus State, which is 341 Georgia Appellate Courts 425, a 2017 case that stands for the proposition that reckless conduct and cruelty to children in the second degree are crimes involving criminal negligence. So while allowing a child access to a firearm and ammunition may not in itself be negligent, such recklessness may be negligent depending on the specific facts presented at trial. And in fact, the wording of our indictment specifically requires that defendant's conduct be reckless by alleging that defendant consciously disregarded a substantial and unjustifiable risk that his act of allowing his son access to a firearm with sufficient warning that his son was capable of harming others. So ultimately, if the defendant has sufficient warning that his son was dangerous, then he should have taken his AR-15 style rifle away from him. And not doing so before his son shot and killed multiple people is criminally negligent. But whether or not the state has sufficient evidence is not the question before the court today. That's pursuant to Putnam versus State 257 Georgia Appellate Courts 902, which states that whether or not an act is criminally negligent is ultimately a question for the jury. The indictment adequately alleges a crime, and it's up for the jury to decide whether or not the state can prove that the defendant is guilty beyond a reasonable doubt. There aren't any cases, obviously, with this specific set of facts in Georgia, but the appellate courts have found sufficient evidence for criminal negligence in circumstances analogous to this case. Other cases where children were allowed access to dangerous instruments or hazards. So while these cases are not based on general demurrers, one of them is, but most are not, what these cases show is that if properly alleged, an indictment would be good or would have been good against a general demurrer. So you have Turnip Seed versus State, which is 186 Georgia Appellate Courts 278, a 1988 case. And that case affirmed a conviction for involuntary manslaughter in the commission of reckless conduct. Even though at the time of the pit bull attack on the child, there was no state law specifically forbidding the ownership of pit bull terriers or specifically outlawing any one of the defendant's isolated acts regarding the dogs, this did not preclude the jury from finding that the acts of keeping the dogs in the circumstances evidenced and leaving them unguarded, all with the knowledge of past incidents, built up to reckless conduct on this occasion. So there, essentially, the defendant did not properly secure his pit bulls. They got out of the house and they killed a child. And that was found to be reckless, and that was found to be the basis for involuntary manslaughter. That case also found that the indictment was not subject to a general demurrer. In Baker v. State, which is 280 Georgia 822, a 2006 case, that case held that evidence was sufficient to support a conviction for misdemeanor reckless conduct when the defendant left his 9-month-old and 3-year-old sons unsupervised on upper floor of a 2-story home near an unprotected flight of downward stairs. Again, did not secure his children away from a dangerous hazard. Reyes v. State, 242 Georgia Appellate Courts 170, a 2000 case, held that evidence was sufficient to support a mother's conviction for reckless conduct and failing to supervise a 3-year-old who was apparently attacked by an animal when evidence showed that the mother allowed her daughter to wander unsupervised, and the daughter was missing for more than 1 hour before the mom began looking for her. So again, not supervising her child, not preventing her access to the outside, and that resulted in reckless conduct. Johnson v. State, 341 Georgia Appellate Courts 425, a 2017 case, found evidence was sufficient to uphold involuntary manslaughter, reckless conduct, and cruelty to children in the second-degree convictions where defendant left her 4-, 3-, and 2-year-old children completely unattended for an extended period of time in a room where they were sleeping on a mattress that was placed directly on the floor next to a space heater. Essentially, the court found that the mother knew that space heaters can catch fire, that they barricaded the children in the house so they could not leave, and when the space heater did catch fire and killed 2 of the children, that was found to be reckless and also involuntary manslaughter. So again, they put the children next to a dangerous hazard and did nothing to prevent them from being injured. Johnson v. State, 292 Georgia 856, a 2013 case, held that a jury could reasonably have concluded, based on the evidence, that the defendant acted with willful wanton or reckless disregard for her son's safety, both in failing to prevent her son from accessing her methadone medication and in failing to seek medical treatment once it became clear he was ill. So essentially, Your Honor, those cases show that an indictment for reckless conduct is sufficient against a general demurrer if it alleges a crime. The crime here being not preventing his child access to a gun when he had knowledge, when he had warning that his child was dangerous. And if the jury finds that he should have taken the gun away from him, then it is criminally negligent and he can be found guilty of these charges. And the state is just requesting that you let the jury decide that and not grant a general demurrer.
What's your best case on it, Mr. Hobbs? I know it's nothing may be directly on point, but
Sure, Judge. As to, and Mr. Berry will give the court this information more in his argument, but as to the proximate cause, reasonable consequence, there's Bell v. State, which is 317 Georgia 519. That is a Georgia Supreme Court case. And I never know how to say this one, but there's Melancon, Melancon v. State. And do you have the site for that, Mr. Berry?
I do, Judge. I have copies of those.
Okay.
That if I can put it in.
yes, sir. Mr. Hobbs, did you want to make any final argument on the specific demurrer?
Judge, I think both arguments are fairly clear, and I think the court has a pretty good grasp of what we're dealing with this. Obviously, this case is a little bit different than the cases that were cited, just based on there being a third party in the form of Mr. Colt Gray who actually committed the action which is intended, but I know the court's aware of that and will rule appropriately. Thank you, Judge.
All right. Thank you. Mr. Berry, you want to do the general?
Thank you, Judge. Good morning.
Good morning. The specific, Yeah, you would do the specific.
Your Honor, the thing that we know about the indictment in this case is that he's not charged as a party to a crime nor as a co-conspirator. So it's kind of a hybrid indictment. In all 29 counts, it's interesting that the language is exactly the same in all 29 counts as to what allegedly occurred. I've given the court the case of Melicant. I think that is the leading case right now. There are a couple of cases that are going up, have been sorted up to the Supreme Court, but I think this is the leading case right now. It was decided in September of last year. And basically what it says, Judge, is that for each kind of murder set out in our statute, the state must prove that the accused caused the death of another human being. In looking at all of the previous cases that led up to Melicant, cause is broken down into two parts: a cause in fact and legal cause, which they have outlined in Melicant as proximate cause. In addition to cause in fact, the decisions describe a separate requirement that they call proximate cause. That's in Bell versus the state at 317 Georgia 523, Eubanks versus the state 317 Georgia 563 and 565, and Jackson versus the state at 287 Georgia 648 and 649. The overall elements of causation required: the murder causes is proximate cause, and that elements include cause in fact and legal cause. Legal cause requires foreseeability or likelihood of death happening in the way that it did or alleged in the indictment, which gives the defendant the conduct which they allege. When you look at the indictment based on Melicant, there's some striking things that you see. In the beginning of the wording, they say consciously disregarding a substantial and unjustifiable risk. This is the language that's used in reckless conduct, but they use it in each one of the charges. All 29 charges uses this same wording. The problem is you are using wording from reckless conduct in a murder charge, murder in the second degree, which is very vague. Which one are they talking about? Are they going to argue reckless conduct, or are they going to argue murder in the second? That language should not be in the indictment. Secondly, in looking at the indictment, they indicate that access to firearms is an issue. There's no requirement under Georgia law that people have their guns locked away. I think it's come before the legislature a couple of times. That has not been, no law has been passed in that regard. Even if you lock your guns away, what is access? Somebody can break into a gun case, get the guns out. So what do you mean by access? Is it just that everybody's going to have to get rid of their guns if they have kids under a certain age? We don't know. It's not specific in the indictment.
Now let me ask, so just trying to think of an analogy there. There's no law that says you can't leave your prescribed narcotics on the coffee table. But you could certainly be charged if you left open prescribed narcotics on a coffee table and a child came and overdosed. I mean, would you disagree with that, or?
Well, you can take that analogy a lot of different directions. if I have an automobile, I have a 16-year-old, and I know my 16-year-old's gotten a couple of speeding tickets, but I leave the keys in the kitchen, and my 16-year-old gets the keys, drives down the road, runs into somebody and kills them. The access to the keys, is that the proximate cause of the murder? It's very vague at best, and that's why we're saying the indictment is vague in and of itself on a number of levels. That just being one of them.
And I realize we have a uniqueness here with the third-party actor.
Correct. This is one of the most bothersome parts of the indictment to me, is it says, after receiving sufficient warning, we don't have any clue what that sufficient warning is. I don't know. I've looked at all of the discovery. I don't know what that sufficient warning is. It doesn't outline it in the indictment. So how do I know what a sufficient warning is? Is it your son's having some problems? Is that a sufficient warning? I don't know, because the indictment does not say. So how can we say that a warning is the proximate cause? Because we don't know what that warning is. It's interesting, too, that in the indictment, it alleges that this occurred on or about September the 4th. On or about September 4th. We don't know what sufficient warning he received on or about September 4th, because they put it kind of in a capsule. It's got to be close to September the 4th. We don't know what that warning was close to September the 4th. And was it sufficient? What does sufficient mean? How do we know? Because they haven't outlined it in the indictment. The next part of the indictment, which is confusing, is that Colt would, after getting this sufficient warning, that he would cause bodily injury to somebody. Now, where in the indictment does it tell us that he knew he would? Not that he may, but knew. It's not in the indictment. We don't know how in the world he would have known unless Colt told him. We've got Colt's statement, unless he's made some other statement that we don't have. He's not made that claim. So how would he know that? We don't know. The indictment doesn't tell us. The indictment basically, I think, Judge, shows some conclusions that the state has. But what we have to have in an indictment is primary facts. We have to have some facts to go on. So in this indictment, the reason we've demurred to this indictment especially is that the state's failure to properly allege the probable cause issue. There's nowhere in the indictment that it uses the word probable cause. And two, the state's failure to allege that the death was reasonably foreseeable consequence of the defendant's action. And we don't know whether it's the defendant's action or inaction. They really haven't told us whether it was an action or an inaction that the defendant did in this indictment. Since they were not alleged in the indictment, there's no way to determine whether the grand jury found sufficient probable cause to issue a true bill. Additionally, the indictment lacks specificity as to material elements of an indictment. For those reasons, Judge, and I think the indictment just is very vague. It does not put us on notice of exactly what we have to defend. It does not allege probable cause or foreseeability of this knowledge. So in our opinion, it's too vague and should be either the state can redo it or this should be thrown out. Thank you.
Thank you. Ms. Brooks?
Yes, Your Honor. Well, to begin with, as I stated earlier, reckless conduct in criminal is regarding criminal negligence, and so is cruelty to children in the second degree. The only difference is that cruelty to children involves a child, reckless conduct would involve an adult. So the language can be the same because it's essentially the same charge, with the only difference being the age of the victim. Involuntary manslaughter is based on the death of an adult. Cruelty to children or murder in the second is based on the death of a child. And I think it's important, Your Honor, when we are talking about special demurrers, that we actually cite what the law and what the standard is. And under State v. Lehman, 279 Georgia 340, a 2005 case, while it says an indictment must be perfect in form, that does not mean that the state has to allege every fact and every piece of evidence that we are relying on in proving our case. What the defense appears to want us to do is to go through each and every piece of evidence that we have and each and every fact that we have, but that is not the purpose of an indictment. The true test of the sufficiency of an indictment is not whether it could have been more definite or certain. It is whether the indictment, 1, contains the elements of the offense intended to be charged, and 2, alleges the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And that's under Hinkson v. State, 310 Georgia 388, a 2020 case. In considering whether the indictment is insufficient, it is informative to remember that the purpose of an indictment is to allow the defendant to prepare a defense. It is not for us to tell them everything that we are going to present at trial. We've given them discovery. They know what we are presenting at trial. We are not required to outline every piece of evidence in our indictment. As far as each count in the indictment, the state did allege each and every essential element, which is prong 1 of the requirements to withstand a special demurrer. So for cruelty to children, those elements are 1, cause cruel or excessive, 2, physical or mental pain, 3, to a child under 18, 4, through criminal negligence. And here we charge each of those elements. We charge the type of pain, the name of the child, and what act constituted criminal negligence, which is, quote, consciously disregarding a substantial and unjustifiable risk that defendant's act of allowing his minor son access to a firearm and ammunition after receiving sufficient warning that defendant's son would harm and endanger the bodily safety of another. That is his act of criminal negligence. And essentially it's the same thing for reckless conduct. We indicted each and every essential element that is outlined in OCGA 16560 and charged the defendant with the harm that he caused, the victim's name, and the specific act of criminal negligence. Now for murder in the second degree and reckless conduct, it's essentially the same elements, but you add proximate cause. And to go along with the defense counsel's analogy, whether or not you know that the 16-year-old driving the car, the dad giving him access to that car, was the proximate cause of death is up for a jury to decide. It's whether or not the jury finds that it was reasonably foreseeable that the child would kill somebody. And that is the same case here. Something is the proximate cause of someone's death if the person could reasonably foresee that someone would die as a result of the actions. Pursuant to Eubanks v. State, 317 Georgia 563, a 2023 case, proximate cause requires that the death actually happen in a way that was a reasonably foreseeable result of the criminal conduct. But what constitutes proximate cause is undeniably a jury question and is always to be determined on the facts of the case. And that's Butler v. State, 363 Georgia Appellate Court 753, a 2022 case. And for indictment purposes, what that means is that the state has to allege an act that could, under any circumstances, result in the death of another. Under any circumstances, be the proximate cause of the death. That's Graders versus State, 263 Georgia Appellate Court 754, a 2003 case, and Funk v. State, 296 Georgia 371, a 2015 case. And in this case, the state alleged that the defendant acted with criminal negligence by disregarding a substantial and unjustifiable risk, that is, act of allowing his son access to a firearm, again, after receiving sufficient warning that his son would harm another. The plain language in the indictment requires that harming another by use of a firearm be within defendant's knowledge and therefore reasonably foreseeable. We put the wording in there of sufficient warning. The defendant had to know that his son was going to do something or was capable of doing something in order for him to be responsible for the actions of his son. And that in itself is reasonably foreseeable in the indictment. And going along to the next argument that the state should have been more specific with regard to whether or not we charge party to a crime, what access the defendant gave his son, and what warnings specifically he had. Well, again, an indictment does not have to contain every detail of the crime to withstand a special demurrer, and that's Kimbrough versus State, 300 Georgia, 878, a 2017 case. And again, sufficiency of the evidence is separate and distinct from sufficiency of the indictment, and that's State versus Hart, 183 Georgia Appellate Court, 737. According to Scruggs versus State, 309 Georgia Appellate Courts 569, a 2011 case, the state does not need to spell out in the indictment the evidence on which it relies for a conviction. Simply put, the law does not require the state to further define essential elements of the crime. We have to put what the essential elements are. We have to apprise the defendant of the evidence he is to meet so that he can prepare a defense, and the state has done that. And I want to go through some examples. Again, we have a unique set of facts, but we have a lot of cases, a lot of charges from where additional facts are not required. So you have Hinkson versus State, 310 Georgia 388, and Arthur versus State, 275 Georgia 790, which hold that for aggravated assault, an indictment need not say how the defendant used the weapon or even what that actual weapon was. So to say that we have to put the exact warning and the exact access would contradict the fact that you don't even have to put what the weapon was in an aggravated assault. State versus Tate, 262 Georgia Appellate Courts 311, which is a 2003 case, found that a terroristic threats indictment only alleging the crime of violence that was threatened as opposed to the actual wording of the threat was sufficient. So all they had to say was, did threaten a crime of violence, to wit murder, and that was fine. They didn't have to say exactly what he said. They didn't have to say the means of communication for the terroristic threats. In Snyder versus State, 238 Georgia Appellate Courts 55, a 1999 case, an indictment for cruelty to children and child molestation did not allege the specific immoral and indecent act that constituted child molestation and cruelty to children. And that was found sufficient. So they didn't even have to say how the defendant molested the child or caused the pain, and that was fine. In South versus State, 268 Georgia Appellate Courts 110, a 2004 case, that was an aggravated stalking indictment that was sufficient even though it didn't allege the exact ways in which the acts of aggravated stalking occurred. So in this case, the state has put the defendant on notice. The incident date, and he argues that we did not provide a detailed date or that the date isn't sufficient. Well, what the date is the date that the defendant giving his child access to a gun resulted in people dying and people being injured. That is the date. We didn't say the date of the warning. It was what knowledge he had at the time he allowed his child to have access. And that is the date, and that was September 4th of 2024. They are on notice of the date. They are on notice of the specific victims' names. They are on notice of the act that the state is alleging was criminally negligent, again, giving his son access to a firearm, not taking it away when he knew that his child could harm others. And we allege that the defendant's actions were the proximate cause of the deaths of Christian Angelo, Mason Skirmahorn, David Aspinwall, and Christina Yeremy. Specifically with regard to party to a crime, the state doesn't have to allege that. That is long settled law. There's no requirement that we put in any sort of indictment that the defendant was a party to the crime of someone else's actions. So that is under Leaks versus State, 303 Georgia 104, a 2018 case. Indictment did not need to be charged with defendant's culpability in it to be proved in that manner. That is also Metz versus State, 284 Georgia 614, a 2008 case. The law is well settled in Georgia that the state is not required to specify in the indictment that it is charging the defendant as a party to the crime. Specifically with regard to the warning that the state alleged, indictment after, or charge after charge has the phrase knew or should have known in it. And the term sufficient warning is analogous to knew or should have known. Statutes like theft by receiving under OCGA 1687, which requires the defendant knew or should have known the property was stolen. Drive-by shooting under 1615 4.1 requires that the defendant knew or should have known a building at which he fired a gun was occupied. Or harming a public safety animal, OCGA 1611 107, that requires that the defendant knew or should have known the animal harmed was a public safety animal. There is no requirement in the law that demands that the state allege what knowledge the defendant had in each of these cases. And it's the same in this case. There is nothing that says the state has to prove the specific warnings or the specific knowledge that the defendant had when he let his son have a firearm. Requiring the state to outline each and every warning that the defendant had would not only make this indictment entirely unwieldy and just pages upon pages long, but it would also require the state to prove elements that is not required to under the law, and it would give us a heightened burden of proof that we are not required to have. Ultimately, it is for the jury to decide whether the evidence presented is sufficient to prove that defendant's knowledge and actions rose to a level of criminal negligence. And the state respectfully requests that the court allow the jury to do that and deny the special demurrer.
Thank you, Mr. Berry.
Thank you, Judge. One thing that the state didn't talk about is this new case, Melancon. It requires that you allege proximate cause. They don't do that. They don't say that because he got this notice, that was the proximate cause of the death. Because of the access, that was the proximate cause of the death, or foreseeability. Both of those are outlined in the Melancon case, and I think that certainly it's very important. And when we don't expect, and we know that indictments are not perfect. However, you are to put in an indictment what you allege that you're going to prove. You have to put us on notice what that is. And if you read the indictment, and they say some of the cases say it's just known that it's knew or should have known, that's not what's in the indictment. That's very specific. He knew because he was given specific warnings on or about, and they said, well, we don't have to put exact date that he got the warning, but that's not what the indictment reads. The indictment reads that all of this was on or about the 4th of September. So we have to assume that that notice was given on the 4th of September because that's what's in the indictment. No knew or should have known. And I think when you read the Melancon case, which is a case from last September, it's the most recent case. There are two cases that have gone up to the Supreme Court with similar situations. They have not been decided yet, but this is the leading case right now on what proximate cause, what you have to show in proximate cause. And none of the things that they put in that case are alleged in the indictment. And we still believe, Judge, that they should give us some information as to exactly how this specific warning was given, by whom to him, when he got it, how he got it, what that warning was. I mean, how do we argue proximate cause if we don't know what the warning was? It's not in the indictment.